Thank you for joining us for our wonderful family trusts session for the wonderful world of family trusts. Just a little bit of housekeeping. Firstly, I'm hoping you can see me. I obviously cannot see you, and you will be muted. So if you do have any questions throughout the session, please just post a question on the Q&A section, which should be on your screen, and I will likely stop about halfway through the presentation to try to address any questions. Anything I can't answer on the spot, I'll hopefully do a bit of research if I have to and get back to you afterwards. So yeah, without any further ado, we'll kick it off. Hopefully you can see my slides on the screen. If you're having any difficulties hearing me or seeing anything, please post on the Q&A and we'll try and sort you out as soon as we can. All right, so yeah, so I should have introduced myself. I'm Glenn Waldock, one of the directors here at Byfields, and I did present a similar session at a breakfast meeting we had several years ago. So there's a few changes to the family trust world since then, but not a heck of a lot. So yeah, if you attended that one, you might be well versed in what we're doing. All right, so I will, sorry. Just got Sophia helping me out here. There we go. So yeah, just a general disclaimer, it's general information only. So common types of trusts. So we obviously have the discretionary trust, which is commonly named a family, also known as a family trust. That's what we're going to be focusing on this morning. But there are other trusts that exist. We have a unit trust, which is a little bit like a company. There's fixed entitlements in a unit trust. There's a hybrid trust, which is a trust that's a combination of both fixed elements and discretionary elements. Testamentary trusts, they're something that they're born out of somebody's will. When someone passes, you leave instructions to leave assets to a trust. That is known as a testamentary trust. We have child maintenance trusts, which is something that are born out of, say, a family separation where there's an obligation to pay child support. They are less common, and something not on the slides is a deceased estate is also a type of trust, but we will focus on our family trusts only today. So what is a trust? A trust is, it's really a relationship between the trustee and the beneficiary, and I'll go into what those are shortly. There's a relationship that concerns trust property, and trust property can be a business, it can be shares, it can be an investment, but yeah, it can be many things. And important to know that a trust is not a separate legal entity itself, like a human is or a company is, but we often refer to a trust as a vehicle. So we talk about vehicles in which to operate a business or in which to invest in. It can be a company, you can invest via a superannuation fund, you can invest via a trust, you can invest via a partnership. So although it's not a separate legal entity itself, it is still a very common vehicle in which people operate their business or investments. So we'll skip to the trust deed itself. That's a very important document that legal advisors, they create these trust deeds, which governs what the trust can and can't do, and the important roles within it. So if you do have a trust, you'll have one of these trust deeds filed away in your cabinet, no doubt. And we always have a copy of these on file as well. So the roles of the trust, we need a settlor. So a settlor is someone who has to provide the trust or the trustee with an initial piece of property, and it's very commonly $10. So when your accountant will set this up, it's quite often we call a settled sum. So $10 is deemed to have been given to the trust, and that starts the life of the trust. And it's usually the settlor is usually your accountant, or it can be a lawyer, it can be a family friend. It's usually someone that's not involved in the trust whatsoever and doesn't have any key position or role. We all have a lot of $10 notes sitting in our safe here at Byfields. that proves existence of the the creation of the trust. If anything was any dispute later in life, or heaven forbid anything went to court, we would have to prove that the trust was properly created, and that $10 note is proof. So funny enough, we'll have a lot of these in our safe here. So that's the settlor. They really have a role at the start and don't do anything else after that, to be honest. The trustee is the very important position. That is the legal owner of the trust assets. Has the day-to-day control and decision-making capacity, and it can be an individual or individuals together, or it can be a company, otherwise known as a corporate trustee. So important to note, if you have an investment in a trust, let's say you buy a investment property, the title will never be in the name of the trust. You'll never see the trust name on the title at Landgate. You'll always see the trustee. Similarly, if you buy a vehicle in a trust, you'll always see it licensed to the trustee. So the documents behind the scenes will prove that it's purchased by the trustee on behalf of the trust. But if you're ever looking for a trust name on a share certificate or a Landgate title or anything like that, you will very rarely see it. So it's the trustee that owns this asset on behalf of the trust. Okay, so we're talking about when talking about an individual trustee versus a corporate trustee, we generally ask a few questions such as, what is the trust going to be doing? Is it going to be carrying on a business? Is it going to be carrying on investment activities only, such as share portfolio or rental property? And what kind of risk is it carrying on? So we're really looking at, is it an active type of business or is it a passive type of business? So a corporate trustee is generally best practice if it's a active type of business, i.e. you're carrying on a business, whether it be a cafe or a retail store or a construction business or something like that. And I'll run through why that's important now. So we have two choices. So we have individual trustee or a company. So you'll see in the diagram, if it's a active, like a trust that's carrying on a business activity, there's likely to be employees. There may well be bank debt. There may well be just your people that you owe money to, called creditors, which are your suppliers that you buy things off from time to time. So if anything was to go skew, and the trust was to run into some financial difficulty for one reason or another, it's the bank or third parties like creditors, it can even be maybe employees, that will be chasing the trust for money, because invariably if something's going wrong, it means you owe money that you're having difficulty paying more often than not. So the importance of a trustee company in this environment. So if the trust doesn't have enough funds, so there's, let's say creditors can successfully or have successfully sued the trust for money, then the trust will be obliged to pay that over to the creditors. Now, if the trust itself doesn't have enough money or assets, then the next step creditors go to is the trustee. So herein lies the problem. If the trustee is an individual, or say mum and dad together, then their personal assets are at risk. So you can see in the diagram there, the personal assets to the right, that's your car, your home, anything you own outside of your business structure. So if the creditors are successful and the trust has run out of money, then they chase the trustee. So therein lies your house is at risk, your car's at risk, your personal share portfolio is at risk. But where a company is in that role as a trustee, and provided the company itself doesn't have anything in it, and that's the purpose. If we have a trustee being the company, we make sure, and our advice is, nothing else is purchased in that company. We call them $2 companies. You might have heard that saying. So all that's in there is $2, which is really one or two shares to start the company. And that's all that's in there. So if the trustee is sued or the trust is sued, the only funds available to the creditors are what's in the trust, and they can't go beyond that. So that's a very important thing, especially if you're creating a business activity and you're going to have debt. Hope that makes sense. Continuing on, one of the other benefits of a corporate trustee, so a company as opposed to individuals, is if there is a death event for one of the trustees, then you are required to change the name of whatever investment it is that you have in the trust. So if it's a property, you would be obliged to go to Landgate and change the name of the trustee. If it's owned in an individual name, or say mum and dad together, you have to update records to at the Landgate. If you own shares or like listed shares, you'd have to go to the corporate registry to get the trustee name changed there. Or if it's a business name, you'd have to go to ASIC and get the business name ownership changed from, say, mum to dad or dad to mum, whoever passes away. So the benefit of a corporate trustee is none of that is actually required. The company name doesn't change. It's just behind the scenes, the directorship or the shareholdings might change behind the scenes, but that doesn't require you to go to Landgate and update anything. So look, there is a cost to operate a corporate trustee. ASIC will charge, at the moment, I think it's $290 just for the privilege of having a company. If your registered office is at, say, Byfields or another accounting firm, we would normally charge a fee to have have ourselves as the registered office as well. So it can cost around, let's say, $600 or so for the privilege to have a corporate trustee. But yeah, that's the only downside, I suppose, that small cost. And the benefits are quite strong, especially if you're operating a business, to protect your assets. Okay, so we'll keep on going with what the other roles are. So we have an appointer and a guardian are the other key roles in a trust. So we call the appointer God. And that's because the appointer is the most powerful position in a trust. It has the power to appoint a trustee, or heaven forbid, if the trustee is doing some wrong things or dodgy things, it has the power to remove the trustee. So whoever is named as the appointer is a very powerful position, has ultimate control of what that trust is doing. So the trustee will have day-to-day control of what it decides to invest in, but if it's not doing the right thing, then the appointer can replace that person. A guardian is it's still important, less important. It has the role of the guardian or protector, they call it, and it generally needs the sign-off of the guardian to make some important decisions, like distributing capital out of a trust, or some amendments to the deed also requires the guardian approval. Look, in a family situation, it's quite common that all three might be the same. So your appointer and guardian are generally the same people. They don't have to be, but usually they are. They can be, say, dad, and then the backup can be mum, or vice versa, or it can be mum and dad together. And quite often the trustee might also be the same people. So that is quite common, but it doesn't have to be like that. We've seen situations where the appointer might be a dad, but the trustee might be the son or daughter. So it's really the son or daughter's operation to control, but dad has really not wanted to hand over full reins, and yeah, in the background can keep that position of control should anything go wrong. So yeah, very important role, that appointer one. Beneficiaries. So obviously the trust in the first place is set up to benefit the beneficiaries. The deed will dictate who they can be. So there's things called primary beneficiaries, specified beneficiaries, general beneficiaries. They can be defined by name. So Bill, Jan, Sue, for example, or more like this. The primary and specified beneficiaries are generally defined by name, but we see that the general beneficiary, so who else can be a beneficiary, is usually defined by the relationship to that person. So the father of Bill, the mother of Bill, brother, sister, nieces, nephews. So there's quite a wide net of who can be a beneficiary of a trust. Sometimes we get asked, like, who are the beneficiaries, as if it's maybe only mum or only dad or only son or daughter. But in reality, there's a wide net of who can be a beneficiary. But provided they haven't they've never been allocated any income or capital, then they're not really, we said they're not active. They can be, but it's up to the trustee year on year to decide if that person is going to get an allocation of income or profit or capital. So they really remain dormant, and they might never get an allocation of profit at the end of the day. But they can, if the trustee decides, and maybe with advice from an accountant, there might be tax effective to bring in a beneficiary that's never had an allocation before. That's a year-on-year decision. So other important thing in a trust is something called the vesting date. So in simple terms, a vesting equals closing the trust. So a trust generally has a lifespan of 80 years, and this dates back to, I think, Old English law or something well beyond my time, but it's 80 years is a set lifetime of a trust. Some older deeds you'll see get established with an earlier vesting date, and therefore different reasons. We've seen in recent times a trust that was created on the death of mum and dad, and its vesting date was defined as when the youngest child reached 21 years of age, and that can happen. So when the youngest child hit 21, that vest had to close. But most common is an 80-year vesting date. So what happens when the trust vests? Assets, if they're still operating a business or there's still assets in the trust at that time, they must vest in the beneficiaries, so vest to the beneficiaries. And important to note, there can be capital gains tax implications and sometimes duty to vest those assets out to the beneficiaries. So that has to happen, unfortunately. So yeah, hopefully the advisors are on their front foot when vesting date is nearing, because there's some planning that is required in the lead up to that. Important to note also, the assets can be vested out to beneficiaries much earlier than that vesting date. That 80-year date just signals the official end if it hasn't happened before that. I will just, there's a question on Q&A. I'll see if I can answer that one. What if the appointer dies, Max? Good question. So often in a deed, you'll see a provision for who the appointer is and who the default appointer is, or backup appointer. So that's where you get an opportunity to name who becomes appointer if the original appointer passes away. So if there is nothing named in there, it might say the appointer becomes the legal personal representative, which is, in other words, is the executor of your will, can be in that position if you pass away. And if that is vague or it's not referenced in the actual deed, you can direct that if you hold a position, direct in your will that if you're the appointer of a XYZ trust, you can direct for the new appointer to be wife or son or daughter to that effect. So yeah, there are a couple of ways you can nominate who the next appointer is. And you want to do that obviously well before you pass away, but that's how that's done. So this is another question. Is it possible to continue the trust or register a new trust instead of vesting and transfer funds to a new trust? How would you minimise capital gains tax implications? Okay, that's a complicated one, Yolandi. But short answer is yes, you can register a new trust instead of vesting, but more often than not, to transfer assets from trust one over to the new trust, there's also going to be capital gains implications, capital gains tax, and sometimes duty. So the government don't give you too many outs to transfer trusts out, so transfer assets out of a trust. The second part of your question, how do we minimise capital gains tax implications? That's probably a topic for another day. There are ways to reduce tax. There's small business concessions. It really depends on what the assets are that you're trying to move from A to B. So property, for example, or rental property has different potential concessions as opposed to a business that you're trying to move into a different trust. So yeah, capital gains tax is something we'd like to think we can help try and minimise, but sometimes it's difficult. But we certainly do. That becomes part of the discussion before we do anything like vesting or transferring out. Lawrence has asked, is there a beneficiary whom the assets vest in by default once the vesting date arrives? Yeah, there is, Lawrence. I think they're called, I'll stand corrected, but the primary beneficiaries or the specified beneficiaries, and they're always named in the trust. They are usually the beneficiaries where the assets vest in when that vesting date arrives. So it might often be the children of, say, the mum and dad who might have set the trust up. All right, I'll revisit the Q&A at the end of the session to see if any more questions have arrived, but hope that's all making sense so far. Okay, ownership, control, and decision making. So, short answer for who controls the trust is the appointer. So as I've touched on before, they don't really do anything from a day-to-day position, but they have the ultimate power. So we call them the controller, and that can be, it's generally mum or dad or mum and dad combined who created the trust in the first place. They're normally the appointer. The decision-making is left to the trustee. So, yep, it's up to them. There are rules in the trustee that what dictates what the trustee can and can't do, or generally what the trustee can and can't invest in. But there's quite wide powers that the trustee generally has to what they can do with the trust, how they invest the money and so on and so forth. As far as who owns a trust, so there is no one owner of the trust assets. So that as I mentioned before, the trustee has legal ownership of whatever asset it buys on behalf of the trust or as trustee of the trust, but no one person or a group of people really own a trust. So a bit of a common misconception when people talk about estate planning, we sometimes get asked, well, who do I leave the business to, or the rental property to? If those assets are owned in a trust, well, you cannot leave them in your will. So you can you can nominate who you want to control the trust once you pass, if you're the controller, but there's no such way of allocating certain assets in your will if it's owned by a trust. Hopefully that makes sense. Okay, distributing income. So I probably could have touched on it earlier, but one of the main purposes of creating a trust is, firstly, asset protection. As I mentioned before, we're trying to separate our business or investment activities away from our personal activities. So that's why we create one of these in the first place. And another advantage can be tax minimisation. So trusts are allowed to allocate the profit or income it makes to a family group, and that can often result in reducing tax. So that's an attractive measure to why we would want to start a trust in the first place. So who can receive a distribution? Obviously family members, minors, so those that are under 18 can receive an allocation of income, but there is only, it's a very small limit that the government allow. It's $416 at the moment and has been for a few years now. So there's not a lot of tax benefit to allocate to minors until they hit 18. A company can receive an allocation from your trust. Other trusts can receive an allocation. So you'll see the deed will often define that you have to be involved in that company or trust as well for it to be able to allocate income. But we make sure those boxes are ticked if we're ever going to go down that path. A non-resident, so you might have a sibling or a child living overseas, they can receive an allocation. There are different taxing issues surrounded by sending money overseas. So that's something we're always wary of, but it can happen. Charitable institutions. So maybe the local church or Salvation Army, things like that, for example, I should say, they can be beneficiaries of a trust as well. So importantly, read the deed. If you go outside the deed, there can be a lot of pain points. So the deed is really the Bible that we really got to stick to when we're talking about allocating income from a trust. So distributing income. So often with the newer deeds, different types of income can be streamed to different beneficiaries. So this can be particularly useful if there's a sale of a business or sale of an investment property or sale of shares. A capital gain could be triggered. You could have one beneficiary in the family group that might have a prior sale from years gone by that triggered a capital loss. So we would look to try and utilise that beneficiary if we can, and stream a capital gain to that person as opposed to other people in the group, because it has some really strong tax benefits associated. So that is possible, and we do look at that all the time, whether there's benefits to stream different types of income. So franking, the types of income are generally what we call franked income, which is your dividends you might get from share portfolios. Capital gains is another type, and everything else is into a pot of other, really. So if your trust is an older trust, hopefully you've been advised by ourselves or your advisor in recent times to have a look at getting that updated. So that might enable the trust to be able to stream income where it otherwise couldn't before. If income is distributed against trust rules, so the rules in the deed, the tax can be payable by the trustee at the highest marginal rate. So the highest rate is 47% at the moment, so we avoid that at all costs, trying to go outside what we're allowed to do. So that very rarely happens. If that happens, we'll probably slap ourselves on the wrist. We've done something wrong somewhere along the lines, but hopefully we haven't seen that yet. Deciding on and recording distributions. So all trusts have to have a minute or a resolution prepared before 30 June every year. So it must be signed off by the trustees on 30 June or before 30 June. And that's a statement saying who the trust is going to be allocating the income to. As far as how much to allocate to and who to allocate to, look, it's difficult to know that if you don't do any planning and forecasting, I guess. You might have some good records to know what income or profit the trust might make. So, yeah, you might have a crystal ball, but otherwise it's difficult to know and get a good tax outcome of who our trust allocations are going to be made to if we don't really know what the income is going to be. So I guess that's what we are doing, and I'm assuming a lot of advisors are doing, probably April, May, June every year, is I guess estimating and forecasting what the business or trust might end up with at the end of the year, and looking at which beneficiaries on which tax rates to try and get pretty close as much as possible to a tax effective resolution of where best we send this money, because yeah, technically you're not supposed to make that decision after 30 June. It's all part of trust law, unfortunately. So those of you with trusts would have seen something like this from us, hopefully. This is just an example of a resolution. The government keep tinkering with trust law. The tax office keep tinkering. So over time, our trust minutes probably look longer than they ever did before, because the requirements of what you've got to include in a resolution are more so than they were probably 5 or 10 years ago. So I'm not going to read through an example word for word, but you'll probably see at the bottom of the first page there is the crux of resolution, where you're nominating, as an example, the first $100,000 to be allocated to Lucy, the next $100,000 to be allocated to Simon, and the balance to Karen. That's a common wording of a trust minute, and it's very hard to know, as I said before, without some planning involved, is where to direct that money in a tax effective way. So that's what you'll be receiving from us before 30 June every year, and you do have the right to change those minutes as long as they're changed by 30 June every year. So how are trusts taxed, I should say, sorry. So yeah, again, a common bit of a misconception, especially for those that are starting out with a trust for the first time, asking how much tax does a trust pay? Well, they don't. Trusts themselves will not pay any tax. The only time a trust will pay tax, it's really the trustee, is if we are allocating income to a non-resident, for example, or going over certain thresholds for minors, or we are allocating outside of the trust rules, then the trustee itself will be picking up the tax bill. But generally, apart from if those things don't happen, then it's the beneficiaries, so the family members will pay tax at their personal marginal rates. And remembering, as a company can be a beneficiary as well, the company might would pay the tax at the company tax rate if they're receiving an allocation as well. So a little example, we have a trust that makes a profit of $1,000 from their business operations or from rental income. It distributes $400 to mum, $400 to dad, and $200 to son. And in this example, because mum is on a lower tax rate, she might be looking after the kids and not going back to work yet. The tax on her $400 allocation is only $75. Dad, on the other hand, is working full time, or also on a decent, already on a decent salary, for example. So you might find he gets his $400 taxed at near the top tax rate. And son might be a 15-year-old at school still. So providing it's under that $416 limit, there will be no tax on that $200. So you'll see on this profit of $1,000, this family pays tax of $265. So that's how it works. Really, it's the individuals that will pay tax at their rates. Hence comes the science that we hope we help with in trying to minimise that number as much as possible. Okay, so beneficiary loan accounts. What are these? So in every trust, if you operate a trust, you'll see the financials that you get every year. There will be a beneficiary loan account section. That's a running balance of what it's called an unpaid present entitlement. It's what you are owed by the trust. So in that previous example where, say, trust distributes mum, dad, and son $1,000 between them, it's quite common that that money isn't physically paid over. So it might be, it's common for the trust to retain that money to continue on with its working capital or business operations. So it's an amount owed to the beneficiaries from prior year profits being allocated or current year profit being allocated. It's a record that we must keep that shows at any given point in time how much does the trust owe to the beneficiaries. And very important to know, it's a legal entitlement to the beneficiary. So even though it might be something on, it might be seen as something on paper that the accountant did just to save us tax, which is all well and good, it is actually legally owed if the beneficiary calls on that money. And that can happen if there's a family breakdown, or I'll give an example of a marriage breakdown. That is legal money owed to them. So it's something to be very wary of. Commonly, what's more common these days, and it might have been 50 years, obviously, is marriage breakdown. So if let's say son or daughter has been allocated, they're over 18, they've been allocated a decent sum of money for the last few years, maybe to assist in tax minimisation, for example. Let's say son has a unpaid present entitlement owed to him of, let's say, $300,000. It's been money allocated on paper that he's paid tax on, but he hasn't got it yet. If he was involved in a marriage separation, that $300,000 forms part of his asset pool, or the couple's asset pool. So it's, although it can have its obviously pluses to be allocating to family group, we really do have to watch out for growing beneficiary loan accounts or growing entitlements. And as long as everyone's aware of it, then that's okay. But it's prudent to be managing how much these grow by, especially if you find kids getting older, getting married. Ideally, we don't want very large present entitlements sitting in a trust for this reason. So Section 100A. Now, I don't want to get too technical here, but this is a something that's very new in trust world. So last year, the tax office scared the hell out of everyone in the accounting profession and everyone with trusts. It's a piece of legislation I think is 40 years old or so, but at the end of the day, what it's there, the government have changed their interpretation of this section and are targeting allocations to adult children where the children do not get that allocation. So as my third point there, their concern is tax avoidance. So it has been quite common to be able to allocate income to we call them adult minors, so adult children. So they're over 18. They might be at university or they might be at TAFE, might have a part-time role in a job only. So naturally, their tax rate personally could be lower than mum and dad's. So it's been quite an effective solution to allocate money to adult children, and if they don't get that physical allocation because it sits in the trust still, it just sits there as an unpaid present entitlement. And this has been happening for probably 40 years. The tax office came out and said, we don't like that anymore. We don't have an issue with allocating trust income to adult children, but we do have an issue if the trust doesn't give them the money. So what they don't like is if, let's say, allocate $50,000 of trust profits, but they can see the $50,000 actually went to mum and dad, which is quite common, but it's a big change in their thinking, and I guess what they want to see is the allocation paid out to the beneficiary within 2 years. That they've come out and said the 2-year mark. Or if they're unable to receive that allocation, then ideally a documented plan as to how the trust envisages getting them that money. So, we need to consider allocations to adult children more carefully than we ever did. It's not dead and buried, it's just a consideration. And it's also, we're advising that the trust needs to change its records of how expenses for kids are treated. So everyone that has a trust or would have records kept either on a zero file or a mild file or some other way, and quite often expenses might come out of the trust for kids, which might be help to buy a car or to pay their board or pay their rent or just university costs, for example. Mum or dad might have been a bit tardy in just saying it's really a drawing for themselves personally. And that was, maybe not so much of an issue, but until now. So we're really encouraging our clients to be very prudent with how they record money that they give their kids. So if it's coming out of the trust bank account, then we certainly want that treated, coded up as a drawing to the child now, and that helps reduce that loan that they're owed if they've been receiving allocations. Another option is if mum or dad are going to help, say, son or daughter buy a car or pay a deposit for their home, and the money is sitting in their account, mum and dad's account personally, then we're suggesting it might be an option to first put that money into the trust bank account and have the trust pay that deposit for the house or the car for a child. Then we can treat that as, again, bringing that unpaid present entitlement down and showing the ATO that we're getting that money to them. You might ask, can the kids just pay if the trust pays an amount of cash out to the adult children, can the kids just pay it back to mum and dad under the table? Be wary of that. The ATO are onto that. So if you do, or if you're unlucky enough to get a review in this space, they would be looking for that kind of thing. They'll be looking at bank accounts to prove that if the trust did pay out the child their allocation, when I say child, their adult child over 18, they would be looking that money didn't come back behind the scenes. Unfortunately, it's early days. We haven't seen a review, but from their commentary, that's what they're going to be looking for to make sure the child gets it and they keep it. Other few other points to note around this is it now becomes a discussion on the tax saving that a family might get to allocate a certain amount to their children versus the risk that is associated with not paying over that allocation or not being able to pay that allocation. So what we sort of heard, if there's a trust that isn't flush with cash or assets because mum and dad take it out to live on, and that's fine, then they're saying the risk is higher because they can see, well, it's very hard to say, well, our plan is to help son or daughter buy their first house and we'll give them a large deposit to do so. If there's a history of the trust not having much cash in the account because mum and dad take it all the time, then it's a harder plan to prove that this is actually going to come to realisation that they are really going to get that money to them. So just something to consider. The ATO are also coming out saying, although they can pick on you or target you at random, what they're saying is they might review this as a part of a wider audit. So if you've got a family group or a taxpayer that's being dodgy, and they want to get them, then they might use this as a way to get them, if that makes sense. They might be auditing other measures through hiding wealth or something. This is just another string to their bow that they can say, well, if I can't get you on this because you're too clever, we're going to look at Section 100A and see if we can get you on that. So it's not to say we never know what the ATO or when the ATO are going to come out and tap you on the shoulder. But I guess the take-home message is if you're complying with your tax obligations, not doing anything dodgy, you reduce the risk of getting an audit in the first place. So you reduce the risk of this ever being reviewed as well. So once upon a time, if we did allocate money to adult children, and that was sitting there for a few years, we were able to have a legal document prepared that legally assigned the money that the kids were owed back to mum and dad, which would extinguish the debt that the trust owed the kids. That was quite effective. That is now a no-no, unfortunately. They have come out and said that they are particularly targeting anything like that, which proves to them there was the allocation was only made for a tax minimisation purpose only. So yeah, why did they do it? I guess is what their argument. So trusts, I guess, have become a little bit more of a complex beast than they were. They always were pretty complex, but if you have a trust, talk to us. The allocations to adults are not dead. We've just got to have a plan in place to look to how we're going to get that money to them in the future. Byfields are now preparing acknowledgement letters if we do allocate, or that you do allocate to your adult children. There's letters we're recommending be signed by the children to say, yes, we acknowledge that I've got the allocation and I acknowledge that you're holding the money in the trust and that you're going to get that to me over time when we can, or something to that effect. It's just, yeah, it's an important probably document to have in the top drawer these days. So yeah, without being too technical, that's the big shift in trusts as opposed to what they were for the last 30 or 40 years, is being wary on how we allocate profits now. Now this graph just demonstrates the risk associated with allocating to adults in certain positions. So let's say the adult is a director of a trustee of the business. So it's got a formal control in that whatever the trust does. What they're saying is there's almost no risk of allocating them profit because they are one of the controllers. They're just like a mum and dad controller. So allocating them income is, let's say, very minimal or no risk. If the adult child is in a management position of the business, then again, pretty low risk of being allocate them money because, yeah, again, they're entwined in what the trust does. So what they're really targeting is for the child, the far right, the adult child that's got a different job, he or she are at university, not involved with the trust. So they're saying, well, why would we allocate to them in commercial terms. So you can see that the spectrum of being really involved with the trust to having no involvement. They're saying that it's a higher risk if you're allocating to children with no involvement in the trust. And that's something we're looking at as well when we make allocations now. So I hope I haven't scared off anyone too much with that, but that's just the reality of what the tax office and the government do. They try and pick holes in any tax minimisation ways that we can get through using a trust now. Right, so a really a good advantage, another strong advantage of why we use trusts as well, apart from income saving and tax minimisation, is succession. So they're a really good mechanism to passing the business or investments onto the next generation. So an example of mum and dad are retiring and sons or daughters wish to take over the business. If the business was in in an individual owned or perhaps a company structure, then there might be tax implications associated with moving the business down to son and daughters. And that might be having to sell shares to them or transfer assets to them. The positive of a family trust is the ease of transition. So providing the deed allows, we are allowed to change the appointer and guardian from, say, mum and dad to son and daughter. We can change the trustee over from mum and dad to son and daughter. And all this can be done with, so generally, no tax or duty implications. So it is an effective way of passing assets or businesses to the next generation. And that's quite a strong structure to be able to do that. Have a note there, be wary of resettling the trust. So resettling a trust is where you make too many changes to the trust that it doesn't look like it was before. So it's called a trust resettlement, where you get hit with capital gains tax and possibly stamp duty on transferring assets or changing too much of the trust. The trust law would say, well, it's not the same trust anymore. You've really just moved the wealth from A to B. You've changed it too much. And normally, if we were to change the specified beneficiaries or the primary beneficiaries, that's an example of where you could resettle the trust. But between us and our legal advisors, we're very careful not to change those positions. But we can change a lot to move assets to the next generation without triggering tax and duty. That's the aim. If your deed doesn't allow you to change those roles, then it's well worth getting a lawyer to look at the deed and potentially vary it or update it so then it does allow. So deeds get updated and varied quite often if required. That's what the lawyers do. So if something can't happen, we would look to get it changed so that we can make it happen, and we'll soon get told from a lawyer if you've tried to make a change that's not possible. And then we have a whole realm of other issues to think about if that happens, but hopefully we don't have that too often. So what we can do is a beneficiary can renounce interest in a trust, and this is often done as a result of marriage breakdown is the most common. So there might be husband and wife that are involved or being a beneficiary of the trust. We can get a legal document prepared to say that they no longer have any interest anymore. Another common reason might be for Centrelink benefits. So mum or dad might be approaching pension age or in age pension age, where if they are an appointer, as an example, we've seen it happen where if mum and dad have no real involvement in the trust anymore, but they're still named as an appointer, the Centrelink will see the assets of those trusts primarily as theirs. So we usually recommend mum or dad relinquishing that role and moving the appointer role to someone else in the family. But we've got to be wary of, it's called a gifting rule. So if mum or dad were to relinquish that position, usually you've got to wait 5 years before you can apply for the pension, because the government, they make you wait. Long story short, they make you wait 5 years before they treat it as an asset of yours for the 5 years after the point you remove yourself as an appointer. So again, a bit of forward planning always helps if mum or dad are of pension age and would be eligible, but for the fact that there's this trust in the background that they've had. Okay, so what makes a discretionary trust a family trust? So as I've talked about, discretionary trust, there's beneficiaries are named as per the deed. But to make it a family trust, so I know I said they're one and the same, but there's some tax advantages to redefine a discretionary trust into what we call a family trust, basically. And why do we do that? So if a trust has losses for one reason or not from prior activities that we want to start using because it started making some money, or the trust has dividend income from a share portfolio or from owning shares in a company that want to flow down to beneficiaries, the tax office make us have what's called a family trust election. So we need that document in place to claim the losses and claim the franking credits, which we certainly want to be able to do. So a family trust election is just something that it sometimes it closes the net of who we can allocate to. So it'll dictate that a family trust election, we have to name an individual. I won't get too complicated here, but generally the lineal descendants of that person is who can be allocated income from that trust. And provided we stay within those boundaries, we can get the tax advantages that are afforded to trusts. So if we've ever talked to you about can you sign a trust election or we need to do a family trust election, it's usually to try and give get some tax benefits flowing to you. Okay, so other issues associated surrounding trusts is obviously estate planning. So if you are involved in a trust, so you're the trustee or the appointer, pretty important to have a will in place. You may want to, again, as I was touching earlier, you might want to dictate or nominate who becomes your successor appointer, and that can be done in a will. You also can forgive amounts owed to you by the trust in your will. So, if you've built up a present entitlement or an unpaid present entitlement or a beneficiary loan account, in other words, of X amount of dollars, you can nominate in your will that should something happen to you, you want that forgiven. Without that, the trust might be forced to potentially sell down assets to pay out your estate. So that's something you should be definitely speaking to your advisors about. And hopefully if you're getting wills prepared with us, we've been talking about that with you as well, but something important to consider in your estate planning. And finally, we want to avoid court involvement at all costs. So we've heard some horror stories. If trustees or if a trustee wants to act outside the wishes of what the rules dictate, you've got to apply to the Supreme Court to make things happen. And dollar signs start ticking. It's very expensive to get something changed via a court process. So I guess hopefully, as your advisors, we're sort of on the ball enough to make sure that doesn't happen. But generally, I think the rule of thumb is try to avoid court at all costs for any trust changes. That concludes what I wanted to run through today. I hope that made a little bit of sense, or if you currently have a trust, it just reiterates what you knew or what you thought you knew, how your trust operates. I'll see if there's any more questions. So I have a question. Are there any tax or compliance issues to be aware of, excuse me, for distributions overseas? Yes, the answer is yes. So again, it can be a little bit complicated, but if you're allocating, I think from memory, franked income. So if your trust is involved in having share portfolios that you get franked dividends from, usually allocating that to a beneficiary overseas can be tax neutral. So a good thing, you don't pay tax here and the beneficiary shouldn't have to pay any tax there. Because the government's really already collected their tax from the company that's paid the dividend. If you're allocating what we call non-franked income, so everything else, then there can be tax implications to do that. Sometimes a trustee has to pay additional tax. So, yeah, short answer to your question, yes, there's always issues we need to consider before we start allocating income to non-residents. From Scott, is there a minimum age a child must be to allocate income to them? No, there isn't. So a 1-year-old child can get an allocation from a trust. As I mentioned before, the maximum amount a child can get between the age of 0 and before they hit 18 is $416. A trust there's nothing stopping a trust allocating more than that sum, but there's very severe tax rates associated with going over that. It's higher than, I think it's 66%. It used to be, I think it still is. So it's well above the marginal tax rate if you want to allocate a child more than that sum of money. So yeah, that's why we never recommend doing that. But yeah, Scott, there's no minimum age. If there's no more questions that have hit the Q&A. Look, if you do have a question beyond the session, please reach out. I believe Shane and Sophia, who have helped organise, have left an email address as a contact point. So if you have any questions in the meantime, please put them on, post them, and we will see if we can help you out. Otherwise, that concludes, I'll just stop sharing my screen. That concludes the session. Thank you for joining us. I hope you got something out of that. We'll likely have another one in March or April in the new year. So please stay tuned and on the lookout for our following topic. But yeah, if I don't speak to anyone in the meantime, thanks for joining, and everyone have a good Christmas and New Year. Yeah, thanks very much. Bye-bye.